You've probably spotted those headlines insisting Trump greenlit 5 brand new firearms for 2026. Sounds dramatic, but here's the actual narrative. This goes well beyond a few weapons receiving clearance. What's materializing is a comprehensive transformation in how citizens purchase, assemble, and document their arms quietly. Whole classifications, previously entangled in bureaucratic obstacles, are suddenly accessible once more. In this analysis, we're ranking 5 of the most significant transformations currently shaking up the firearms landscape. And when we arrive at position 3, you'll understand why merchants are replenishing inventory, advocacy organizations are applauding, and firearm safety proponents are raising urgent concerns. Ignore the sensationalism whether you're currently carrying or considering it. This represents the genuine developments, and you must grasp every nuance. Position 1. The comeback of stabilized AR handguns. Let's begin with what reopened the marketplace. AR pattern pistols featuring stabilization braces. Visualize this: a condensed AR-15 featuring an abbreviated barrel, absent conventional shoulder support, and a brace engineered to encircle your wrist. Portable, agile, and ideal for residential protection or vehicle transport. For extended periods, these configurations remained completely lawful and extremely favored. Then, enforcement arrived. During 2023, the ATF, beneath Biden's leadership, delivered a devastating blow. They redesignated the majority of braced handguns as abbreviated barrel rifles, subjecting them to National Firearms Act oversight. That necessitated compulsory documentation, a $200 revenue stamp, extensive documentation, and prolonged authorization intervals. Essentially, overnight, countless proprietors learned they needed adherence or risked severe repercussions. Judicial challenges emerged immediately, advanced to mid-2025. The litigation, designated Mack versus Garland, revolutionized everything. Trump's Justice Department silently abandoned its challenge, permitting a judicial determination to remain intact. That judgment dismantled the brace prohibition, and with the challenge dismissed, it covered the entire nation. Interpretation: these stabilized handguns no longer fall under NFA classification. Eliminated. The revenue stamp, the documentation, the months-long delays for authorization to retain equipment already secured in your vault. The Firearms Policy Coalition labeled this an enormous triumph for constitutional freedoms. Producers such as Maxim Defense, who contributed resources toward the judicial struggle, commemorated the ruling as a pivotal moment in restoring Second Amendment safeguards. However, firearm restriction organizations were devastated. Certain factions even suggested this might result in de facto automatic weapons flooding communities. That's inaccurate. These remain semi-automatic devices, not fully automatic weaponry, though it demonstrates how fierce the resistance grew. Here's the essential takeaway. Stabilized AR handguns previously trapped in regulatory uncertainty have returned to availability. Retailers nationwide have commenced restocking them, and for countless responsible proprietors, these compact systems have reclaimed their liberty. Absent bureaucratic complications, absent taxation, absent unpredictability. Position 2. Sound suppressors, abbreviated barrel rifles, and the elimination of the $200 revenue stamp. Let's examine among the most substantial economic obstacles in the firearms community: the notorious $200 revenue stamp. For almost a century, possessing a sound suppressor or abbreviated barrel weapon demanded paying that additional $200 beyond your existing expenditure. Irrelevant whether your suppressor priced at $900 or your abbreviated barrel rifle represented a personal creation. The federal government still demanded its share, and that charge. It's remained fixed since 1934, never modified for economic fluctuations, never simplified, merely a flat taxation accompanied by extensive documentation and months of anticipation. And all of that, it's ultimately transformed. Through substantial legislative achievement, Congress enacted comprehensive firearms reform legislation during 2025, and President Trump approved it on, predictably, Independence Day. Embedded within that bundle was a long-needed correction. Effective January 1st, the federal excise taxation on sound suppressors, abbreviated barrel rifles, and even particular shotguns was entirely abolished, vanished, eliminated. You still undergo criminal background verification and ATF documentation, though that $200 charge at entry. History. To contextualize, a household acquiring suppressors for 3 rifles now preserves $600 immediately. A competitive marksman developing an NFA assortment could preserve thousands, and that excludes temporal savings from accelerated processing beneath modernized procedures. The National Shooting Sports Foundation designated this a generational advancement, among the most impactful methods to equalize opportunities for legitimate firearm proprietors. And indeed, retailers already observe the transformation. Purchases have increased, producers are expanding manufacturing, and the suppressor sector, which numerous considered specialized, now anticipates substantial expansion during 2026. For years, individuals postponed acquisition merely due to that supplementary expense and postponement. Presently, there's no justification, at minimum at the national level. Naturally, not everyone celebrates. Detractors, such as Representative Mike Thompson, contend this measure prioritized enhancing firearms industry earnings above community welfare. Certain individuals worry that additional suppressors circulating might hinder law enforcement's capacity to identify discharges during emergencies, though advocates counter forcefully. They emphasize that suppressors don't render firearms noiseless. They diminish acoustic levels to safer thresholds, particularly for auditory preservation. Additionally, the lawful procedure still encompasses complete documentation and criminal background verification. Essential point: this isn't distributing silencers freely among the population. It's abolishing an antiquated taxation that penalized responsible firearm proprietors for nearly a century. The regulations persist, the documentation persists, though the economic barrier has disappeared. For countless Americans, that's an enormous victory, and it's actively restructuring the marketplace currently. Position 3. Personal defense weapons and specialized configurations have been liberated. This marks where developments shift from intriguing to astonishing. We're addressing personal defense weapons, those compact, high-capacity firearms chambered for 9mm or rifle ammunition appearing as if extracted directly from elite military equipment. Beneath previous frameworks, they operated at legality's periphery. Presently, they've emerged into prominence and become fully accessible for civilian possession. Weapons including the SIG MPX, Scorpion Evo, HK MP5 reproductions, and even the Ruger PC carbine existed previously in restricted versions. Acquisition remained possible, certainly, though solely if they adhered to rigid specifications. Should the barrel measure beneath 16 inches or overall dimensions drop below 26 inches, immediately. It transformed into an abbreviated barrel rifle beneath federal statutes, activating all typical NFA complications. Individuals became inventive, employing braces as lawful alternatives, though even that adaptability was eliminated during Biden-era constraints. Fast forward, the brace prohibitions are eliminated. The $200 revenue stamp for abbreviated barrel rifles is eliminated, and instantly, opportunities have exploded. You may now arrange these PDW pattern firearms however you prefer. Attach shoulder support, reduce barrel length, optimize for residential defense without becoming entangled in obsolete regulations. Desire to install a collapsible shoulder support on a Scorpion and operate it like professional-grade equipment? You can. Prefer maintaining it as a stabilized handgun configuration? That's restored as well. What we're witnessing currently represents a comprehensive regulatory reconstruction. Firearms previously occupying regulatory ambiguity are now entirely legitimate, and it extends beyond common models, specialized and exotic configurations. Equipment such as belt-fed upper receivers, military pattern arrangements, or ultra-compact PDW packages are receiving authorization in manners unseen since prior to NFA implementation. The sector is already advancing. Firearm manufacturers are sketching prototypes and reviving archived designs previously too hazardous to introduce. It's not hyperbole to suggest this might ignite a golden era of firearms innovation. From compact residential defense arrangements to complete tactical configurations, the creative barriers have collapsed. To maintain organization, the ATF, beneath Trump's guidance, established a formal classification panel. No more speculation games or inconsistent agents issuing conflicting determinations. Novel designs now undergo a centralized procedure delivering consistent, transparent judgments regarding legality. that didn't exist previously. One evaluator might approve, another might reject. That's how complete product categories became buried beneath bureaucratic complications. Presently, there's a manual, and realistically, Trump didn't enter a media briefing and authorize some futuristic weapon by designation. What occurred here exceeded that. His administration demolished regulatory barriers that had constrained innovation for decades. In doing so, they granted civilian firearm proprietors access to alternatives previously exclusive to military or NFA collectors. This isn't merely concerning impressive equipment or appearing tactical. It's concerning options. It's concerning rights, and it's concerning the capability to construct a firearm arrangement matching your requirements without requiring payment of hundreds, waiting months, or hoping regulations don't abruptly transform. If you've ever envisioned a residential defense setup with genuine stopping capability and nimble handling, or you simply appreciate modular rifle platforms, this represents your opportunity. The regulations have transformed, the obstacles have vanished, and for the initial occasion in a generation, the civilian marketplace has space to expand. Position 4. Forced reset mechanisms, lawful enhancement, or automatic weapon loophole. Now, we enter the disputed territory. Forced reset triggers, commonly abbreviated FRT, have remained central to among the most contentious conflicts in contemporary firearms regulation. These represent drop-in trigger mechanisms for AR pattern rifles, enabling remarkably rapid successive discharges, not fully automatic operation, though nearly. Following each round, the trigger mechanically resets forward, and if you maintain pressure, it discharges again almost immediately. It still demands individual activation per shot, though to most operators it feels startlingly similar to fully automatic. Beneath Biden's administration, the ATF handled these mechanisms as prohibited goods between 2022 and 2023. They categorized FRT as unlawful automatic weapons. That triggered unexpected inspections, high-profile raids against companies including rare breed triggers, mass confiscations of merchandise, and even prosecution threats for ordinary purchasers who installed them. It was aggressive. Firearm rights organizations retaliated, arguing that FRT don't satisfy the legal definition of automatic weapons since the trigger still activates once per discharge. They referenced Cargill versus Garland, where federal judges determined the ATF exceeded authority in a comparable case involving bump stocks. Then arrived the unexpected development. During May of 2025, Trump's Justice Department delivered a legal surprise. Rather than prolong the conflict, they resolved the major FRT litigations and agreed to cease enforcement of the prohibition. Additionally, the government consented to return confiscated merchandise to legitimate proprietors, though they established one boundary. FRT remained banned for handgun applications. Why? The concern is evident. A forced reset AR handgun or Glock pattern build would be compact, concealable, and discharge almost uncontrollably rapidly, generating serious concerns for law enforcement and legislators alike. The manufacturers agreed against marketing FRT for handguns, and the restriction remains. So, where does this position us? Currently, you may lawfully install an FRT in your AR-15 rifle. No revenue stamp, no NFA documentation, and no federal agents monitoring your activities. That signifies millions of existing rifles may now be enhanced to cycle nearly as rapidly as military-grade M4s while remaining technically semi-automatic beneath statutes. Firearm rights advocates immediately proclaimed victory. Dudley Brown, from the National Association for Gun Rights, designated it a landmark reversal of unconstitutional overreach and among the most substantial triumphs in years, and they might have validity. For years, the ATF was expanding its automatic weapon definition far beyond statutory language. This reversal represents a clear limitation on that authority. On the opposing side, firearm restriction organizations exploded. Giffords and the Brady campaign issued scathing statements accusing the Trump administration of unlocking access to weapons of warfare. Gabby Giffords personally cautioned that lives would be sacrificed, arguing that these mechanisms provide ordinary rifles battlefield comparable discharge rates with minimal oversight. And honestly, when you hear a rifle with an FRT empty a magazine at the range, it genuinely sounds like an automatic weapon. To some, it's exhilarating. To others, horrifying. Though here's the legal reality. One activation, one discharge. That remains the standard. FRT might obscure the boundary regarding acoustics and speed, though beneath statutes they're still semi-automatic. The distinction now is that the federal government concurs, at minimum concerning rifles. Whether you interpret this as a breakthrough for liberty or a careless invitation for misuse depends on your perspective. Though either way, it's official. Forced reset mechanisms are no longer in the ATF's targeting sights, and for numerous enthusiasts, that's a massive transformation. Position 5. The reality behind the 5 firearms misconception. Let's clarify the facts. No. President Trump didn't execute an order authorizing 5 specific firearms by designation. There's no confidential memorandum, no presidential inventory of manufacturers and models that received approval for 2026. If you searched through executive directives or congressional documentation, expecting to locate a catalog of newly legitimized firearms, you'd discover nothing, because the authentic narrative substantially exceeds 5 individual firearms. What genuinely occurred was a sweeping legal and policy transformation, one that altered the environment for entire classifications of firearms and accessories. Trump's administration, supported by crucial congressional actions, peeled back layers of federal firearms regulations accumulated across decades. And by doing so, they didn't merely clear 5 models, they opened access for millions of firearms previously imprisoned beneath bureaucratic complications. It's comparable to the distinction between excusing 5 inmates or unlocking an entire detention facility. Let's review once more. Stabilized AR handguns are now handled as standard handguns. Again, no NFA documentation, no revenue stamp. Sound suppressors, abbreviated barrel rifles, and other specialized firearms no longer carry that $200 federal penalty for possession. PDWs and exotic configurations are operational again, with the brace prohibition reversed and cost obstacles eliminated. Forced reset mechanisms, previously condemned as unlawful automatic weapons, are now permitted on rifles with explicit handgun restrictions. Though it doesn't conclude there. Trump's Justice Department and ATF didn't merely retreat, they actively reconstructed the system. A formal classification panel was established to assess novel firearm designs, meaning no more confusion or inconsistent determinations from field agents. They also reformed burdensome procedures such as ATF Form 20, converting what previously required weeks of waiting for interstate firearm transportation into a straightforward notification system. And behind closed doors, they've initiated reviewing every significant regulation on record to eliminate those no longer defensible. The transformation is authentic, and it's enormous. For firearm rights supporters, this is being celebrated as the most substantial Second Amendment achievement in a generation. Some are even designating it the most significant reduction of federal firearm restrictions since 1934, when the NFA was originally enacted. On the opposing side, firearm safety advocates view these transformations as careless. They argue it's a hazardous relaxation of safeguards implemented without consideration for community welfare. Either way, one certainty exists. This isn't the narrative's conclusion. State administrations are already mobilizing to address the void. Some are introducing prohibitions on stabilized handguns or forced reset mechanisms at state levels, attempting to restrict what the federal system just released. Simultaneously, fresh litigations are developing, some targeting challenging the very existence of the NFA now that crucial components have been dismantled. So no, Trump didn't authorize 5 gleaming new firearms. What he accomplished exceeded that. He extracted major sections of the regulatory barrier, and presently, millions of Americans are passing through. Final assessment. Trump didn't settle in and approve 5 specific firearms. What he accomplished was considerably more consequential. His administration dismantled crucial components of the federal firearms restriction framework, and that transformation is actively reshaping civilian firearm possession's appearance moving forward. Entire classifications became accessible, enduring barriers collapsed, and the game's regulations transformed in a manner unseen in decades. Presently, the question belongs to you. Do you interpret these actions as long overdue triumphs for Second Amendment freedoms, or as hazardous reversals extending excessively far? Share your thoughts below. I want to hear viewpoints from both perspectives. If this analysis assisted you in cutting through confusion and comprehending what's genuinely transforming in our firearm regulations, make sure you subscribe to Weapons Law Advisor. And don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.